Welcome to Notable Approvals. I am attorney Amanda Shaffer. Today, we have a really great case to talk about a client who has been our client since 2014 and is, I'm happy to say, is finally a U.S. citizen. She had a very long journey, which I will get to shortly. First, a couple of reminders. Number one, make sure to like us and follow us on Facebook and Instagram and YouTube and LinkedIn so that you don't miss any other of our lives. If you feel that this video is helpful or someone you know may find it helpful, please make sure to share it with them. And tonight, the Are You Smarter Than a Naturalized Citizen game show, episode 9, which was supposed to air tonight, has been rescheduled till next Wednesday. I will be posting about it probably tomorrow, Friday, the latest. So, with that in mind, let's get to the case. We have a lot to talk about. Let me get a little bit of water, and then we'll get going. All right. So, this client is a native and citizen of Senegal. Her husband is a naturalized U.S. citizen, also from Senegal. They have a little bit of a strange, well, I'll get to the marriage in a second. She entered the U.S. in 2001 with a B2 visitor visa. However, she lost back then. They had paper I-94s. That's your arrival departure number. Now it's electronic. I think it's after 2013. If you arrive in the U.S., it's electronic. Back then, if you lost it, you had to file a form I-102 to replace your I-94. But, we still had the proof of her entry. We had the stamp, as well as not immigrant visa, but they do want to see the I-94, so we had to file that with it, but we were able to do that concurrently. So the reason I just said that this case is a little different when it comes to the marriage is because of this. When my client's husband filed I-130 for her, that was their second time they got married. So they were first married in 2000, and first they were married. Oh, no. Married another, the client, the applicant was married to someone else first. She was divorced a long time ago. Then her and her now husband got married in 2004 and then divorced in 2012. And then reconciled and remarried in 2014. So even though they have been married for a long period of time, USCIS A still requires the divorce and the new marriage certificate, and B, if their interview ends up being before the 2-year anniversary of their wedding, then she was only going to get a conditional green card, which is what ended up happening. But I'll get to that in a second. So her husband did file an I-130, and we concurrently filed the replacement I-94 application, as well as the adjustment application for her green card, and of course, work permit. This client also had 2 arrests. They were for minor things, basically selling on the street without a license. She was only charged with the crime in one of those arrests, and both were dismissed and sealed. So she wasn't really prosecuted on them, but of course, we still had to mention it. We still had to get their certificate of disposition. All that was great. We go to the first interview, January of 2015, and I never like when interviews go this way. Not because they were not a real couple or they weren't prepared. It was because my client dropped a bit of a bombshell. And she admitted that before she entered with the visa in her own name in 2001, she had tried to enter the U.S. in 1998 with a French passport that was in someone else's name with someone else's information. At the border, when the Customs and Border Patrol questioned her about it, she admitted it pretty quickly, like, yeah, this isn't me, and they refused her admission, put her on a plane back to Senegal. So because of that, at the end of the interview, the officer gave us a paper that said, you need to file a fraud and misrepresentation waiver, because she tried to enter the U.S. fraudulently with the fake French passport. So that meant that although the I-130 did get approved because we had a lot of strong evidence, we were now going to have to file an I-601 extreme hardship waiver. And unfortunately for the client, we had some good basis for the hardship. There are two main categories we focused on, which are financial and medical. For the financial, it was pretty straightforward. Her husband had, so before I get to that, I'll tell you, if you're not familiar with waivers, you always have to prove both that, I don't even know if I started this Instagram. Oh, I think I started the Instagram one. Anyway, so you have to prove both that your U.S. citizen relative will suffer extreme hardship if he or she stays here without you and you have to go back to your country, and that your spouse cannot return to your country with you, that he or she will suffer an extreme hardship wherever he or she is, whether you're returning to your country or staying here. So in terms of financial, we were able to show, look, he has the same job for 19 years. He built up a really good rapport. Ties to community are huge for these types of things, especially if you have someone who's worked a really long time in employment. The whole idea is people move up, they get promoted, they build good rapport, they're well respected, and asking them to now just leave that job and go to some other country where they don't know, or they don't have a job, or maybe even qualifications, that's definitely something we can hit on when we do these hardship waivers. We also, and his employer had a savings plan for him that he saved up over time, which is another important thing too. There's a lot of pensions, things like that, showing if money can be moved out of the country easily or not, if it's needed. And then the big thing though for them was the health concern. Now, there's a pretty serious medical condition her husband had, and even though it's a strong case, and I honestly feel it could have been approved based on that alone, you never sit back and say, I'm only going to put one thing in. You throw in everything that can help. So in this case, the husband had a couple of different things: high blood pressure, high cholesterol, which is kind of, pretty normal in the population. Then he had some prostate conditions and what they called essential tremors. Basically, his right hand would tremor all the time, and even the doctors here couldn't figure out what to do. If you actually look at the applications where he signs it, it just looks like a scribbled thing because he couldn't really hold a pen. So we explained how, number one, he can't go to Senegal. We actually got a letter from Senegal pharmacists saying the medications this guy takes, they don't have. They also, if the doctors here can't handle the tremors, the doctors in Senegal aren't going to be able to handle the tremors. But we can't, of course, just say that. We have to show the country condition evidence for medical treatment and prove that he's getting that medical treatment here as well. So he really did rely, though, on his wife for everyday things. He needed her. If he wasn't here, he would have trouble even like holding a spoon to eat his cereal for breakfast, to cook, to just do daily, everyday, mundane tasks that he needs help for his wife. So there was no way he could stay here without her, and there's no way he could go to Senegal because his already poor condition would have probably deteriorated even more. So we were given, I think, 60 days to submit it, and if we didn't, they would have denied the I-45, but we did. So the waiver was granted, and the adjustment of status application was granted, and she became a conditional resident in May 2015. Again, even though they were married for like a decade earlier, that doesn't matter when we're talking about her getting a 2-year versus a 10-year green card. What matters is the current marriage. Because they remarried, it goes by that date, and that date was in 2014, which was less than 2 years. It was 2014, which was less than 2 years before the green card interview. So she got the 2-year green card. So then we had to file the I-751 petition to remove conditional residency. And for this, that was filed in February of 2017. And we had a lot of good evidence for them. And I remember doing it thinking, they might not even get an interview. We had joint taxes with monthly receipts from the landlord. joint lease with monthly receipts for rent paid to the landlord. You get several joint taxes, joint health insurance, joint checking account, like several statements, and then several joint utilities like Con Ed and cable, and photographs. And then in 2018, we get a request for evidence. And I was honestly, sometimes I'm surprised, sometimes I'm not. More often than not, I'm not surprised. Or I should say I am surprised, because what I've always said here, we try to do everything right the first time so that we don't get delayed with an RFE. But in this case, we got an RFE, and I don't know if it's because it took them so long to adjudicate the application. They wanted more proof of their marriage. So we submitted even more. We submitted even more proof, including more rent receipts, more taxes. I think we had just given their health insurance card, which maybe it wasn't 100% clear that it was joint. So we now given more paperwork, more bank statements that were showing the statements being used over many months and years. So we submitted all of that back pretty quickly. And then again, I'm thinking, all right, well, they got what they wanted. They're going to waive the interview. Well, unfortunately, they didn't waive the interview. I think part of it was the political climate. At the time, the policy was they weren't going to waive anyone's interview. Although we did have some get waived, they didn't waive this one. So in 2019, she had to go to her I-751 interview. It was granted the following week. And by that time, she only by the time the I-751 was granted, she had already had her green card for about 4.5 years or so, because it took so long for them to approve the I-751. So although she was still married, living to a U.S. citizen, she didn't have to check the 3-year box. She waited a few months, checked the 5-year box. I've been a permanent resident for 5 years. And then we didn't have to worry about proving the marriage all over again. And considering the hard time they gave her with the I-751, we decided it was definitely worth the wait. So that's what she did. She waited just a few months, and then because you could file it 3 months before the 5-year anniversary of your green card, and that's what we did. And we filed that February 2020. And of course, right, this woman's not had as much luck in the system right before the pandemic hit. So she did not have her interview until this past March, the following year. And then it was approved in May. And then she had her oath ceremony. So this was a long journey our client had from being a visitor in this country, an overstay, to getting her green card, or 2-year green card, to her 10-year green card, to her naturalization. We've been with her every step of the way. And, there's nothing greater than watching a client who has gone through this journey finally get to the end game, which is the citizenship, to remove any restrictions they may have had or have felt they had because of it. And I know she's a very happy camper. And I know that her husband is doing okay now, but he definitely, still needs her help. So we're very glad that that is no longer a stressor in their life. So that is all today for notable approvals. I will maybe be back. I'm going to try to be back tomorrow, if not next week, for another one. Don't forget to like us and follow us on Facebook and Instagram and YouTube. And if you found this video helpful or sounds like someone's case that might find it helpful, make sure you share the videos so that we can get all this information out there. And of course, our contact information has been scrolling across the bottom of the screen. Please do not hesitate to contact us. Thank you, Lambert, for watching, as always. Thank you all, and have a great day.